Mr. Chief Justice, and may it please the Court. My name is Jennifer Tarr, and I'm SJC Rule 303 counsel from the Harvard Legal Aid Bureau, here on behalf of the defendant appellant, Casey Bailey. I'd like to thank this Court for accommodation of my injury. I'm joined at the table by my supervisor, Esme Caramello. Your Honor, the key question in every post-foreclosure summary process eviction case is whether the evicting party has title to the property. Without title, the bank does not own the property and therefore lacks the right to evict. Yet today, the Bank of New York asks this court to affirm a view of housing court jurisdiction so narrow that it would require the housing court to hear only one side of the key question that bears on possession.
So what does the bank have to do, or I should say the owner have to do? What's necessary to establish title in the context of a summary process case?
Your Honor, the prima facie case in every post-foreclosure summary process eviction is a showing of a foreclosure deed and proof of compliance with the power of sale in the mortgage.
And does that mean just the filing the affidavit that one filed? Was it the Section 15 affidavit?
If that affidavit is fully and particularly laying out the acts that were stated, that would be sufficient to meet out the prima facie case.
So you're saying this affidavit is no good?
This affidavit is not before the court, Your Honor. It was not submitted.
But it is in the record.
Actually, Your Honor, it's not in the record. Bank of New York submitted it in their reply brief, in their red brief, but it was not before the housing court at summary judgment.
Well, would it have been sufficient then if they had simply filed that along with the foreclosure deed?
It would not have been, Your Honor, for
Okay.
two reasons. First, because the affidavit itself did not fully and particularly lay out the facts, lay out compliance with the power of sale, with Chapter 244, Section 14. It merely alleges that they just blankly just complied. It doesn't say, as Chapter 244, Section 15 requires, what they did to comply. But secondly, the issue here is that Mr. Bailey has challenged the bank's prima facie case.
But now the bank says that you didn't challenge in a timely way, that even I think in opposition to summary judgment, you said yes, that the doesn't challenge that the plaintiff acquired title by virtue of the foreclosure deed.
Mr. Bailey challenged at every step, Your Honor. In his answer, he stated that the first time he received notice of the foreclosure was actually 20 days after the auction had taken place. And he stated in his answer that as a result, the bank did not own the property. And in his opposition to the motion for summary judgment, he again stated through prior counsel that he had not received the required notice necessary to comply with the power of sale.
And he filed an affidavit to that effect?
No, Your Honor. Mr. Bailey challenged it in his pleadings, and also there in the original answer is an attached complaint from the Superior Court.
And so your argument is that for purposes of summary judgment, it was a verified complaint? Is that right? That
is one argument to that effect, Your Honor. But additionally, the bank failed to make out its prima facie case, which under this court's opinion in Smith v. Massimiano would be enough without Mr. Bailey having even said anything to deny the bank's summary judgment, because it failed to actually show or state through an affidavit compliance with Chapter 244, Section 14 as required.
But you indicated that the bank has to be in a position of ownership, but I'm not so sure that that's actually right, because a subtenant can, or a tenant can evict a subtenant without owning the property. Isn't the essence of an eviction case a landlord-tenant relationship, or somebody with at least some sort of a default possessory interest?
There are two kinds of eviction cases, Your Honor. In the landlord-tenant context, as this court has held in Connors v. Wick, there is an implied ownership by the landlord. And so there's a sort of estoppel effect by which the tenant or subtenant could not challenge the title of the landlord or of the tenant who they were renting from. But in this context, in the post-foreclosure eviction, where you have an owner and then a bank, both of whom are saying, we own the property, we have the title, the key issue is in fact title. And as this court held in Wayne Investment Corporation versus Abbott, what needs to be done in a summary process eviction action post-foreclosure is a showing of valid legal title. and that a valid defense to the eviction action in such a case would be saying power of sale, which is necessary in order to have a foreclosure and have that foreclosure be valid, would need to be strictly complied with.
Was the mortgagee a party in this case, in the eviction case?
Your Honor, I'm not clear on who exactly the mortgagee is. Unfortunately, the record and the transcript
No, the
are not-
mortgagor.
The mortgagor is, yes, Mr. Bailey.
He was,
Yes.
okay, yeah.
So there are two strands of law, Your Honors, that show clearly that the housing court has jurisdiction to hear title defenses. First, as I've alluded to, this court has held for over 100 years that in a post-foreclosure eviction, the defendant can place the plaintiff's legal title in issue.
That's
And that-
if it's brought in the, I mean, your point is, the only issue here is does the housing, I mean, if this were in the district court, no question, right?
I think that's absolutely correct,
And
Your
if this
Honor.
were in the Superior Court, no question.
Correct, Your Honor.
So the only question is whether, in your view, there's something about the housing court jurisdictional statute that limits it to be able to hear this.
Your Honor, we have contended throughout that the housing
I
court
understand you
does-
say it doesn't,
yes.
but I mean, that's the issue.
Yes.
Sorry,
Bank of New York never challenges this court's line of cases that run from New England Mutual Life Insurance versus Wing through Wayne Investment Corporation versus Abbott. What they're challenging is that the housing court in particular has jurisdiction. But the housing court must have jurisdiction over title, Your Honor. The housing court's prima facie case is in fact title. The bank needs to show that it has a foreclosure deed and has complied with the power of sale necessary to get it titled.
In fact,
And-
doesn't the complaint on which this rests cross out the landlord part and specifically state it's the owner, so the focus is ownership?
The focus, Your Honor, is ownership. If the bank doesn't own the property, they have no right to evict.
Can I go back to the adequacy of the affidavit? You say this affidavit, I know you say it was not filed, and I guess that's, it was not filed until after the fact.
Yes.
Although I assume it was on record with the deed because it would be recorded, correct?
That
affidavit-
should be the case, Your Honor, but
Okay.
on summary judgment, they
All right.
haven't made out their case.
The affidavit says, I also comply with Mass General Laws 244, Section 14, by mailing the required notices by certified mail, return receipt requested. You're saying that's inadequate?
I am, Your Honor. Chapter 244, Section 15 requires the affiant to fully and particularly lay out the acts that they have taken. And so compliance in that instance would be something along the lines of, I mailed to Mr. Bailey on this date the required notice, because otherwise it's simply a statement that they complied with the law, and it's not something that the housing court judge could use to actually address the adequacy of the notice.
Ms. Tarr, would this be the first case where this court has said that the housing court has jurisdiction in these kinds of matters?
No, Your Honor. In Wayne Investment Corporation versus Abbott, this court said that in summary process, which I would take to go along to the housing court, because that is the primary summary process court, that legal title can be placed in issue and that it will be done by challenging the power of sale. And so in this particular case, what we're looking at is a housing court with broad jurisdictional powers under Chapter 185C, Section 3, to look at anything that directly or indirectly affects possession. And that would be something that Wayne Investment Corporation covers.
Would you agree with me the housing court doesn't have the power to set aside a foreclosure deed?
Your Honor, I think not in the first instance, as in if I wanted to bring a quiet title action in the housing court. The housing court does not have that jurisdiction. But
Do the
in
other courts have
instance-
it? Does the Superior Court have that and the District Court?
The Superior Court and the Land Court do
Just
by
those two
statute.
courts?
I'm uncertain about the District Court. But in a case like we have here, where the actual issue is the validity of a defense, Mr. Bailey is entitled to bring that defense because it directly relates to what the housing court properly has jurisdiction over.
So
which
if the
is
housing
possession.
court concludes that, well, the foreclosure didn't proceed according to the statute in some way, denies summary process, then what does the bank do? Does it go into Superior Court to try to quiet title? Is that how that would work?
There are multiple options for what could happen afterwards, Your Honor. The Housing Court has broad powers to issue a declaratory judgment. The decision by the Housing Court would be res judicata on Superior Court or on Land Court, and so for judicial efficiency purposes...
So it doesn't have power to set aside the deed, but it has power to declare it null and void?
Well, it would be void ab initio, Your Honor. So failure to comply with the power of sale in the mortgage renders that foreclosure void. And what the Housing Court is doing is saying, as a result of the void foreclosure, we cannot, the bank does not have the ability to evict. The superior right to possession, because of the void foreclosure, still vests in the owner. And the Housing Court, I'm sorry, Your Honor.
No, go ahead, finish.
The Housing Court could take Chapter 211B, Section 9 jurisdiction in order to then wrap everything up neatly.
But it could seek
Yes,
211B.
yes, Your Honor.
Section.
So I take it this is an unusual case, and what normally occurs in a summary process case is there has to be proof of a landlord-tenant relationship. And in this case, the only way that the bank could show that it was in a landlord-tenant relationship is to show that it was the owner of the property.
Well,
And that's the essence by which it can even commence summary process.
There's a particular statute about it.
yeah, I don't think that this in particular is a landlord-tenant relationship. The summary process statute, Chapter 239, Section 1, has multiple avenues by which you can bring a summary process eviction action. One of them is a landlord-tenant relationship and an allegation of non-payment or fault or something along those lines. But there's also a specific clause in Chapter 239, Section 1 that says if you have foreclosed or are alleging that you foreclosed under a power of sale in the mortgage, then you can bring a summary process action. And so I would view those as separate transactions, and that in this particular case, where you have an owner and an entity also claiming ownership, that the key issue here is title. And so what happens in these cases is that the Housing Court has jurisdiction over possession, and its grant is to determine under Chapter 185C, Section 3, who has the right to possession. And because in these cases title determines possession, the Housing Court necessarily has jurisdiction over it. But if this court were to view the Housing Court's jurisdictional grant more narrowly, it still should find jurisdiction for the Housing Court under the doctrine of incidental jurisdiction, which is explained more fully in the City Life Vita Urbana amicus brief, but which essentially states that when an issue is necessary to determine an issue over which the court has jurisdiction, then the court has jurisdiction to determine the underlying issue. So in this case, if the Housing Court has jurisdiction over possession and title is necessary to determine possession, then the Housing Court has incidental jurisdiction over the question of title.
Would that include, so let me see, the bank comes in, files the things that you say they have to file, the foreclosure deed and an affidavit that maybe is a little more specific. Your client says, well, I don't think the bank, the foreclosing entity, had a proper assignment of the mortgage, and I want to litigate that here. And so what happens? You do a big litigation about title in the Housing Court.
Your Honor, what would happen there is that if as this court has ruled in Ibanez, there's an assignment problem that would render the foreclosure void ab initio.
It could be a complicated problem.
Yes, Your Honor. The bank still has no title to that property and no ability to evict. And so under this court's decision in Wayne versus Abbott, it would be a valid defense to raise.
So we're going to have a real title litigation in the Housing Court.
I don't think that it would necessarily be a huge litigation, Your Honor, but if that's what's necessary to stop a party who doesn't own the property from evicting a party who does, then that is a proper defense to be raised in the Housing Court.
You would say that maybe one approach is that if that becomes an issue, that the bank in such a situation could ask the rather than enter a judgment, could ask the housing court to stay the proceeding while it, I think as Justice Corey suggested before, while it goes to the land court, say, to quiet title.
Or seek a transfer
Yeah.
of the entire case
Yeah.
interdepartmentally.
Right.
Those are absolutely options, Your Honor. The key issue here is that in this particular case, the defense was never allowed to be raised at all. And so a party who possibly does still own the property could be evicted by the lack of transfer.
But you had an opportunity to challenge that in Superior Court. In fact, the reason it was, I thought, unless I've misread the record, the reason that the first summary process was dismissed was precisely so that you could challenge title in the Superior Court.
It was, Your Honor, but there was no res judicata effect because Mr. Bailey was unable to enact service on the proper party. And the reason why we would counsel that this court hold that once the housing court has jurisdiction, because it bears on possession, that it stay in the housing court is for judicial efficiency reasons. It would be duplicative litigation essentially to stay a case that should be summary in its nature.
But this isn't summary once you get into a title dispute.
Right.
I'm sorry, time is up. Thank you.
Thank you, Your Honor.
Good morning, may it please the court. Peter Gallardo on behalf of Bank of New York, along with Mr. Manoogian. What's very interesting, and the court just hit on, is the fact that the case was dismissed. Not only was it dismissed, it was dismissed by stipulation. Stipulation suggested, dismissal suggested by and drafted up, according to the transcripts, by bank's counsel a month after the summary process was commenced. 15 months later.
But you're not suggesting it was a dismissal with prejudice, are you?
It was not a dismissal with prejudice. There was an allowance to bring the same case back within 12 months, which we did not do because Mr. Bailey's case was still pending for 15 months in the Superior Court.
You're talking about the dismissal of the first summary process.
First summary process, 07446.
But you're not suggesting, I guess what I was asking was, you're not suggesting that the Superior Court dismissal was a dismissal with prejudice, are you?
Your Honor, they make a lot of the fact that it wasn't dismissed without prejudice. My point is, whether or not how it was dismissed, the simple fact is that the borrower, Mr. Bailey, had the opportunity to bring that action, and he did. And in fact, he could still bring that action in 2008 after it was dismissed. He could have brought it again in 2009.
But getting, okay, maybe he could have, but you're saying, well, let me ask you just for starters. You say that if this were brought in the district, if you had brought this in the district court, he would be able to do exactly what he says he did do, that is, challenge the validity of your title, correct?
It's possible, and although it is still summary procedure in district court is a court of a lot greater resources. It has 180, district and municipal court has 180 judges.
Well, forget the resources. Let's just talk about jurisdiction. You say that the district court has jurisdiction to hear exactly what he wishes to bring, correct?
In a summary process matter,
isn't the case law?
If title were properly put into evidence, title properly put into dispute, it would, at that point in time, again, we're talking a threshold level, any threshold that we see in any courts. At that point in time, if he properly challenges the prima facie case, then it would be, then we could go forward with bringing up perhaps the receipt, the mailing receipts, or the certified mailing receipts.
You could raise the issue.
These are the certified mailing receipts are the same issues that are brought up when we sell a foreclosed property to a third party. We have no problem bringing that up. What Mr. Bailey seeks to do is, and again, this is not only a threshold question. If you're bringing it up successfully, if you allege scent, because as we know in Hall versus Attleboro Savings Bank, receipt is a non-issue. Non-receipt is irrelevant. You have to allege it was sent. That was not done here, nor was there any evidence requested in discovery. In fact, there was no discovery at all requested.
Well, there is an issue about whether it was sent to the proper address.
It was never actually raised, Your Honor. It was
Why
argued.
do you say that? Why do you say that?
Pardon?
Why do you say it was never actually raised?
It was argued, yes, but argument, as we all know, is not evidence. And the Rule 56E standard requires evidence by way of affidavit and other documentation, which he could have submitted an affidavit.
Certified complaint was not enough. The allegations and the verified complaint. Excuse me.
The verified complaint, although it was not brought before the court, it may be in the record as one of the
I thought it
exhibits.
was attached to the answer.
It was attached to the answer, but it was not brought before the court in the Rule 56 hearing. If you read it closely, and I believe it's page 28 of the joint appendix, it says I didn't receive. And again, we're back to the same problem. Receipt is not sent. And while I'm aware of a evidentiary a presumption that a regular mail letter sent and not returned is deemed received, I'm not aware of any evidentiary presumption or inference that a letter not received was never
He
sent.
can't allege it wasn't sent. He has to allege it wasn't received. And then your counter would be, oh, yes, we did, and not only did we send it to the right place, which in this case arguably is the address on record, and that would have been the right response, correct? He
I
can't
believe
say it
so.
was sent. He doesn't have a clue.
He does not have personal knowledge. The way to do this is through discovery. And that leads me through discovery that says, give me an interrogatory to tell me where to address.
There's no dispute where it was sent, is there?
There's nothing in the record saying where it was.
Where was it sent?
Well, I thought it wasn't sent to his post office
We
box.
don't know that. First off, Mr. Bailey never established in the record that A, he owns a post office box, and B, that the post office box that he refers to was the actual address of record of my client as required.
Wouldn't your client have that information?
Mr. Bailey could have simply filed an affidavit in the Rule 56 and brought in a copy of his monthly
There are
statement.
lots of things that could have been done, but I think the focus here is the proceeding was before the court below. And beyond the
Right.
jurisdictional question, assuming it had jurisdiction for the moment, the papers that you brought forward, also not by affidavit, said something which garnered the response that it did. I didn't get it. And then, assuming that you had an opportunity because there was jurisdiction, then it would be in your ball, correct? And you would say, here are my client's records, and by affidavit, yes, we did what we are supposed to do. That would have
That's right.
in
Judge
the
Muirhead,
transaction.
Judge Muirhead, as the appellate, as am I, as in this court, are bound by that record, and nothing in that record evidences non-sending to a non-address. It's what was, and I'm glad the court brought this point up. The affidavit, the appellant makes a lot of the fact that the affidavit was not produced.
Can I just stop? What do you mean by nothing evidences non-sending? Non-receipt evidences non-sending, and then you establish it was sent.
I'm sorry,
How do you evidence
I spoke too fast for myself. What I meant to say was there's nothing in the record that says it wasn't sent, and nothing in the record that it wasn't sent to an address that Mr. Bailey hasn't established in the record was his.
Correct. There's nothing in there.
There's nothing in this. And if I may, the 24415 affidavit, if I can bring up really quickly, what Mr. Manoogian sought to and did introduce without objection, I might add, as Judge Muirhead notes on footnote 1 of her decision, was document 84985, recorded instrument number 84985 from 2007 in the Suffolk County Registry of Deeds. 3 out of 4 pages of the foreclosure deed were, in fact, submitted, the entire document. And there's no dispute that the document existed and the document was on record 4 floors below where Judge Muirhead sits. If it had been objected to, and at that time we could have easily corrected the matter, gone downstairs, taken second call, or we could have asked, as I asked this court to do, that since it's a matter of public record, easily obtainable, and its authenticity is in question, could take judicial notice of it. In fact, judicial notice is, not only is judicial notice, as this court has said in Jackson versus Longcope, appropriate in summary judgment matters, it's also has been practiced by the land court in Allen versus Town of Dedham and Wareham Land Trust versus Makepeace. At best, the affidavit issue is diversionary, but at worst, it's just a simply curable de minimis defect. And by bringing up the issue and then not allowing us to cure it at this point in time, it's not only prejudicial to my client, it's easily cured. The court doesn't help the court in resolving this matter and looking at it. And I further say that since there's no doubt that it exists and is on record, it's not really prejudicial to Mr. Bailey.
Can I ask you, with respect to the affidavit that you've now put into your record appendix or attached to your brief, counsel says it is inadequate. Is this the standard affidavit?
This is the standard affidavit I've been using for about 18 years that I've been doing foreclosure. In fact, prior to the 1992 amendments of the foreclosure proceedings, the All these documents, including that affidavit, that same affidavit, had to be approved by Charlie Trombley at the land court, now Judge Trombley at the land court. These are exactly the same affidavits. This issue is being brought up, actually, as we speak. There was an appellate division court case called Sarek, I believe, and I believe it's being appealed to the appellate division, where they argued that it was not in compliance or in conformance with, for various reasons. But this is the standard affidavit, and this is the standard prima facie case, the one the only one that I've known and my associates have known. You put the foreclosure documents in evidence, which were done without objection, and we move forward. And again,
if I can interrupt, let's focus on this world in which 80% probably of the persons who are being evicted are going pro se, and are likely to be without funds to hire an attorney because, after all, they're being evicted. When somebody like Mr. Bailey has a challenge to whether or not he received notice of the foreclosure, what realistically are you asking? Are you saying that he must do in order to preserve his right to have a hearing as to whether or not there was a proper foreclosure and the person who was seeking to evict him truly owns the property and therefore is entitled to possession of the property? What pragmatically are you saying they must do?
In this case, Your Honor, Mr. Bailey had not one but two pro bono.
Okay, but then he was unusually lucky. But let's focus on the rest of the world, which is not so lucky and is mostly pro se.
To do what Mr. Bailey started to but failed to complete, to raise it in Superior Court as he could have raised it properly, serve the defendant. In this case, Mr. Bailey knew, as is demonstrated by his motion on Joint Appendix 110, he knew where to serve MERS down in Federal Street, serve CT Corp. He didn't. He let it languish for 15 months. Raise the issue, but raise it to a threshold issue. Show me some evidence and request discovery. Now, again, I point out...
So, I mean, because part of the problem here was that he couldn't figure... Is that I gather the attorney for MERS refused to accept service, correct?
No, that's not correct. John Davis was the foreclosure attorney, and I believe he stated, we're not the proper party. They were not a named party. He said, after the case was dismissed, incidentally, Your Honor, on Joint Appendix 110, Mr. Bailey goes to the Superior Court and says, please reopen this case because I want to serve them care of CT Corp down on Federal Street. He knew how to do it. He just failed to.
So what you're saying then is that the typical pro se, when faced with an eviction, has to then go to Superior Court and file an action in Superior Court. Is that...
Mr. Bailey got a fair shake, and the system worked as
try my
it was
question.
supposed to.
Is that what, when the matter is brought in District Court, I gather they can litigate it right there, correct?
Well, it's still a summary proceeding, Your Honor. I mean...
but they can litigate it right there.
You can transfer it to the civil docket if you want to challenge. And not only that, District Court, as counsel conceded, may likely have right to set aside a foreclosure deed. And as we know...
But you're not questioning that you can challenge the title as part of a summary process in the district court, are you?
I'm not questioning if you reach a threshold, but the second point that I did want to make is how far. And again, foreclosure in the Commonwealth is a series of chopped up events. Right now we have whether or not we challenged the 244-14 provision. How far back are we going to go? The land court, challenge the land court standing, go back in further and challenge the whether or not they were properly served under 244 Section 35A of the 90 or 150-day notice. We're already seeing that in housing court. Even before that, do we want the housing court to hear challenges to whether or not someone was, as we've seen in the bankruptcy in the federal court, whether or not someone was entitled to and was denied HAMP provisions? All of these things, if you open this door beyond the threshold, how far back?
Well, I guess my question is, if those can be brought in district court, why does the fact that the landlord happened to bring it in housing court matter?
As the court has noted previously, and as the appeals court has noted, not only is the housing court a court of limited jurisdiction, it is also a court of limited resources. In fact, some in Murphy versus Miller call it a finite resources.
All of our courts are courts of quite limited resources, district court included.
The housing exactly. The housing court has 9 justices compared to 81 in the Superior Court.
But there's only one at a time with regard to each case. So I mean, it's not.
You're not suggesting, are you, that one should interpret jurisdictional statutes because of some idiosyncratic view of the resources of the court?
That's the admonition in Haas and that is the admonition made later on in the Williams case, to not divert from the core mission, which is the health, safety, and welfare issues of the housing court. You begin adding too much on, you begin diverting. I'm not a very good speaker here, but I will quote from a very eloquent writer, Judge Hillman in the bankruptcy court, specifically speaking about another summary matter. The court need not and indeed should not seek out latent defects of the kind now proposed by the debtor. To do so would subject every motion for relief from stay to a full evidentiary hearing where the debtor, as here, has not articulated an affirmative objection but an investigational inquiry.
You don't argue res judicata.
They could bring the action again. They could bring it now, except for one problem.
But you're not saying that the defendant cannot wage a collateral attack on a superior court foreclosure decree.
Absolutely, go right ahead. But in this case,
no. Are you arguing that?
I'm sorry.
That the defendant cannot wage a collateral attack on a superior court foreclosure decree in a summary process action?
In this case, where we dismissed and they bring the superior court action, go right ahead.
So you're saying that that a defendant can collaterally attack a foreclosure decree?
In superior court, yes.
All right.
All right. My last point was...
No. You're saying that the defendant can collaterally attack a superior court decree in a summary process action?
That would... I don't know, Your Honor. I simply say that may lead to divergent decisions. If I see my time is up, if I may make one last point, which I was trying to get to. Mr. Bailey, in the rush to appeal the singular issue of housing court jurisdiction, they lost sight of one particular part. 2 foreclosures happened on March 6, 2007. The first one by 244. The second one was essentially by entry, 244 Section 1 and 2. That entry has since ripened. It ripened back, after this case was briefed, it ripened back in July 27, 2010. Whatever happens, whatever this court decides with regards to the 244-14 foreclosure, my client unequivocally owns this property now. It might moot the case at the lower court because all we have to do is submit the entry. I have a copy of it, a certified copy here for the court if it so wishes. But in essence, they could have brought this case, they could have brought a superior court case in 2008, 2009, 2010. They could bring it after we get out of here to challenge 244-14. The problem is the entry has ripened. And if the entry's ripened, the second foreclosure is taken for the case. Mr. Bailey no longer has any claim to title. His rights of redemption have been foreclosed.
Thank you.
Thank you, Your Honor. Thank you.